Welcome to today's explainer. We're going to completely bypass all that intimidating legal jargon today. Instead, we are equipping you with a punchy, highly practical masterclass on literally commanding the courtroom. If you've ever felt, tongue-tied in front of a judge, or stressed that a simple grammatical slip-up might totally undermine your entire argument, well, you are exactly in the right place. Today is all about clarity, precision, and absolute confidence. So here's our tactical roadmap for today. We've got 1. Mastering legal English. 2. The golden rule formula. 3. Choosing the right auxiliary. 4. Fixing common verb errors. And finally, 5. Courtroom sentences in action. We're going to start with the foundational blueprint and build all the way up to a live courtroom simulation.
Section 1. Mastering legal English. The building blocks of courtroom communication. Before you can effectively argue a complex case, you really need to firmly understand the basic moving parts of legal communication. And that means we absolutely must define the auxiliary verb right out of the gate. Think of an auxiliary as a helping word. Words like is, are, do, has, will, or can. You use these right alongside your main verb. Now these small, kind of insignificant-looking words, they're actually your secret weapons. They completely dictate the timeline of a legal action. I mean, they are the literal difference between telling a judge your client will file a petition tomorrow or that your client has already filed it today. Massive difference, right?
Section 2. The golden rule formula. Crafting bulletproof legal sentences. Now that we know exactly what an auxiliary verb is and why it carries so much weight, let's look at the absolute blueprint for framing short, clear legal sentences.
This is the core of today's explainer, the golden rule formula. It's just 4 simple steps. 1. Subject. 2. Auxiliary. 3. Verb. And 4. Object. Seriously, if you can memorize this sequence and stack these 4 elements in order, you can confidently build practically any courtroom statement you'll ever need. It totally keeps your thoughts organized and keeps you from rambling.
Let's see this formula in action. Take the sentence, the client has signed the vakalat. We start with our subject, the client. We add that helping auxiliary verb has, then the main action verb, signed, and finally the object that's receiving the action, the vakalat. The client has signed the vakalat. It's crisp, it's undeniable, and it leaves absolutely zero room for confusion on the record. Section 3. Choosing the right auxiliary. Controlling the timeline and meaning. The framework is set, so let's examine our auxiliary arsenal. Picking the exact right auxiliary verb changes the entire reality of your sentence.
It is absolutely crucial to internalize these rules. If you've got a singular subject, like one specific witness, you use has. The witness has given evidence. But if you're dealing with a plural, say multiple respondents, you've got to shift to are or have. The respondents are present. The real key here is understanding intent. Using will guarantees a future action, right? The counsel will file the memo today. But using can simply shows ability or permission, like the accused can apply for bail. If you swap will for can, you completely change your legal commitment to the court.
Section 4. Fixing common verb errors. Avoiding courtroom pitfalls. Let's see how this builds into real-world application. Imagine stepping up to the bench. The courtroom is completely quiet. The judge is looking right at you. The absolute last thing you want to do is undermine your authority with a basic verb error.
So let's test your error correction skills based on what we just talked about. What exactly is wrong with saying the petitioner are present? Can you spot the structural flaw?
Right, so because the petitioner is a singular subject, it's just one person or one entity, we absolutely must swap out that plural are for the singular is. Saying the petitioner is present aligns perfectly with our subject-verb agreement rules. Super simple, but super important. Let's try another one. This is a trap that trips up a ton of junior advocates when they're rushing to explain their client's actions. What's wrong with saying, he have filed the petition?
Again, he is a singular pronoun. We're speaking in the present perfect tense here about an action that was literally just completed. So the rule demands we use has, not have. He has filed the petition. Boom. It instantly sounds so much sharper and a lot more authoritative.
Okay, what about when we're talking about a witness on the stand? A singular witness who is failing to recall an event. How do we fix the phrase, the witness do not remember?
The right way to frame this so it matches that singular third-party subject is to use does. The witness does not remember. When you say it correctly, it just sounds significantly more professional on the record. Plus, it keeps the judge's focus right where it should be. on the facts of the case rather than on some jarring grammatical error.
Section 5, Courtroom Sentences in Action, Simulating the Bench. For our fifth and final section, we are going to simulate a live courtroom scenario and put all these foundational tools and corrected errors together into one seamless presentation.
You should honestly consider this your courtroom sentence bank. These are your go-to rapid-fire phrases for immediate use when the judge calls your matter. Things like, I'm appearing for the petitioner, or the affidavit has been filed. Notice how closely these follow our golden rule: subject, auxiliary, verb, object. They're short, they're highly professional, and they get straight to the point.
But hey, what happens when you're forced to think on your feet? Let's say you're in a rush and you quickly scribbled "court here tomorrow" on your legal pad. When it's finally your turn to speak, how do you translate that rough shorthand aloud to the judge?
Well, by injecting our golden rule formula, we seamlessly transform that broken, incomplete thought into a commanding sentence. We just add our subject, the court, our future auxiliary will, our verb here, and our object, the matter. The court will hear the matter tomorrow. That right there is how you sound like a seasoned professional, even when you're just relying on quick, messy notes.
Imagine the judge says, "Call the matter." You confidently stand up and deliver your response. "May it please your honor, I appear for the petitioner. The respondent is not present. I request a short accommodation." Notice how perfectly constructed those simple sentences are? They flow directly into a highly respectful, totally effective dialogue with the bench. No rambling, no confusion, just pure, precise legal English.
Now, understanding this intellectually is one thing, but to truly master this, you actually have to practice. So here is your task. Write out 10 fresh legal sentences using the auxiliary vocabulary from today. Words like is, has, will, and can. Create sentences like, I will file the written statement, or the petitioner has signed. Write them all down, and then actually practice saying them out loud.
We've built the foundation. You now know exactly how to use auxiliary verbs, you know how to avoid the most common errors, and you've got the golden rule formula totally committed to memory. The knowledge is firmly in your hands. But you know, the true test of an advocate isn't just knowing the rules of grammar. It's finding the courage to stand up in a crowded room and speak these words aloud every single day. So the only question left for you is, are you ready to take the floor?